I see this happen time and time again. Kids are added to the deeds of parents. When I ask why this is done, I'm usually told that the attorney recommended this because it's easier when it comes to probate. Another thing I see is that parents gift their houses to their children while they are still alive. Sometimes this may not be avoidable, where they have to just gift it out for Medicaid planning purposes. That would usually be done through a trust. But in the instances where it is avoidable, I would recommend against it. Here's why. When it comes to gifting assets, the giftee, which is the person receiving the gift, is going to receive the cost basis of the giftor, who is the person giving the gift. For example, with a real estate property, let's say mom and dad purchased a home years ago for $300,000. And for one reason or another, they decided to gift it to their kid. At the time of the gift, the value of the home was $700,000. They essentially gifted an asset worth $300 with a fair market value actually of $700 to a child. When they did that, the child, the giftee, received that gift with a basis of $300,000. What does that mean? If this recipient wants to sell this asset, let's say a week from when they receive it, they're going to be subject to tax on the difference between the sales price, which is probably the fair market value of $700,000, and their basis of $300,000. So they're essentially going to be subjecting themselves to capital gains tax of the difference between 700 and 300, which is 4. That's really not great. So what's the alternative here? The alternative would be for mom and dad, if they really want to do some sophisticated planning and ultimately want that child to have that property, they may place it in a trust. That's a revocable living trust. It's not a completed gift and they could change their mind at any given time and swap out beneficiaries or swap out assets. There are things that you can do with that trust. But what we really want to do is lock in, leave open that step up in basis. And we'll talk about that in a second. If it's an irrevocable trust, that would make that gift a completed gift. It would be the same as gifting the asset to the kid straight out, meaning just deeding it to the kid. So you don't want to do that. So what's the step up in basis that we're talking about? So when a person passes away, their assets are actually stepped up to the fair market value at date of death. So going back to the same example, when mom and dad die, and let's say that asset that they bought for $300,000 is now worth $700,000, the basis now for whoever inherits that property is $700,000, which is the fair market value at date of death. So when the child receives the real estate property at date of death, they get it at a basis of $700,000. So running back the same scenario, if the child decides to sell it the same week, they wouldn't pay tax on the difference between 7 and 3, which is $400,000. They would pay tax on the difference between $700,000 and $700,000, because $700,000 would be the selling price. We're assuming that's the fair market value, and the fair market value, which is what they have as a cost basis now. So you essentially saved whatever the capital gains tax would be on $400,000 by just waiting for the passing of mom and dad to inherit that asset. That's a big difference. And let's talk about deeding the property to kids. Here's another thing that's very concerning. When you deed that property, essentially the same thing happens here. A portion of that asset is now owned by the child, depending on however it's titled, if it's tenancy in common or joint tenancy by entirety, and depending on how much of that property the child owns. So today, if the parents decided to write that kid into their deed, and let's say it's a family of 3, parents and child, and let's say that kid owns a third of the property, the basis in the property for all 3 individuals would be $100,000 each. Mom 100, dad 100, and child 100. Let's fast forward in a very similar scenario to the date of death of mom and dad. So now mom and dad passed away and the child gets the rest of the property. So in this scenario, the child will inherit 2/3 of the property at the date of death of mom and dad. But the child already had 1/3 of the property deeded to him. At that point, his cost basis in 1/3 of the property is still going to be $100,000. That's not included in the step up on date of death. So in the step up, the 2/3 are going to be stepped up from $100,000 each, which is $200,000, to the now 2/3 of $700,000, which is approximately $470,000. So the child will receive this property now with a new basis of $570,000, which is still $230,000 shy of $700,000. So very similar scenario, if the child decides to sell the property the next week, now they're still paying tax on $230,000, which again could have been avoided altogether if they waited until the death to transfer that property to the kid. And now if the argument here is, well, it's easier for probate purposes and we didn't want to create a will, this isn't legal advice, you can speak to an attorney, we can still use revocable living trusts in order to gift that property and still avoid probate, or at least make the transfer a lot simpler than bringing the child onto the deed and having potential capital gains tax issues sometime down the road. There's smarter ways of doing this. I would always consult with a competent tax advisor or an attorney when dealing with such issues, and really understand what you're getting yourself into when dealing with estate and inheritance questions. Hope you found that video useful. Like, follow, and share for more tax tips.